My husband died on a Wednesday morning in early November, at home, in the room we had converted from a study into a bedroom 6 months earlier when the stairs became too much for him. I was holding his hand. The hospice nurse was on the other side of the bed. The window was open because he had asked me the night before to leave it open. He said he wanted to hear the birds in the morning, and I had said yes, and in the morning there were birds, and he heard them, and then he was gone. I sat with him for 40 minutes after the nurse stepped out to make her calls. I did not cry immediately. I had already done most of that crying in the months before, in the hospital waiting rooms and the pharmacy parking lots and the car rides home when I would sit in the driveway for 10 minutes before going inside because I did not want him to see my face. By the time he actually left, I had run through so much grief in advance that what I felt in that room was not devastation. It was something quieter. It was the kind of ache that does not announce itself. It just sits down beside you and stays. I looked at him for a long time after the nurse left. The room was very still. The birds outside were sparrows, I think, though I am not certain, because I am not someone who has ever been good at identifying birds by sound. Douglas would have known. Douglas knew things like that, not because he had studied them formally but because he paid attention to the world around him in a way that accumulated into a kind of quiet knowledge that surprised you at unexpected moments. He would have looked at me from the bed and said something like, "Those are white-throated sparrows, they migrate through in November," and I would have said, "How do you know that?" and he would have smiled and said, "I just pay attention." That was Douglas. 11 years of marriage and I was still sometimes surprised by what he had paid attention to. My name is Sylvia Hartwell. I was married to Douglas Hartwell for 11 years. We met when I was 31 and he was 38, at a continuing education seminar for attorneys that neither of us had wanted to attend. It was a 2-day event at a hotel conference center in the kind of city that hosts events like that, a medium-sized city with a good convention center and nothing else particularly remarkable. And Douglas and I had both been sent by our respective firms because the seminars counted toward continuing education credits and our supervisors had decided we were the ones who could be spared for 2 days. I arrived on a Sunday evening and ate a mediocre dinner alone at the hotel restaurant and went to my room and called my mother and told her I would rather be doing anything else on earth. She said, "Well, you never know," and I said, "I know exactly what this is going to be, 2 days of people reading slides at me." And she said, "You never know, Sylvia," and I said goodnight because I did not want to argue with my mother about a continuing education seminar. The next morning I sat at a round table at the back of the main conference room and opened my notebook and prepared to take notes on things I already knew. The seminar was about changes to a state law in our jurisdiction, which was directly relevant to my practice and which I had already read about extensively in the 3 weeks leading up to the event because that is how I approach things that are required of me. I prepare thoroughly and then I sit through the thing and take notes anyway because thoroughness is a professional habit I do not turn off. Douglas sat down 2 seats to my left at the same table at 8:53 in the morning, 7 minutes before the session was scheduled to begin, and I noticed him the way you notice someone who moves through a room without making unnecessary noise about it. He was tall, and he wore his suit the way some men do, as though it were simply what he was rather than what he had put on that morning. He had the kind of face that takes a moment to process properly, not immediately striking but the sort of face you find yourself looking at twice. He nodded at me when he sat down, not the awkward greeting of someone who does not know what to do with a stranger at a shared table, but the specific nod of someone who has assessed the situation and decided that a nod is exactly the right amount of acknowledgement for this particular moment. I nodded back and we both opened our notebooks and the seminar began. We argued at lunch. It happened naturally, the way arguments between 2 people who are actually thinking happen naturally, which is that someone says something and the other person sees it differently and says so without hedging, and then the first person says, "Well, actually," and then you are 45 minutes into a conversation that has nothing to do with what either of you planned to do with your lunch hour. The argument was about a case study from the morning session, a hypothetical involving an estate contested on the grounds of undue influence, and Douglas took the position that the hypothetical as presented tilted too far toward the challenger's side, that the presumption of undue influence in the scenario was not adequately supported by the facts as given. I took the position that the facts as given were deliberately ambiguous and that the entire point of the exercise was to sit with that ambiguity and examine your own assumptions about where the burden of proof should sit. Douglas said, "You are arguing that the ambiguity is the point." I said, "I am arguing that anyone who resolved that hypothetical without feeling the ambiguity probably resolved it wrong." He looked at me for a moment with the expression of someone who is genuinely reconsidering something, not performing reconsideration but actually doing it, and then he said, "That is a more useful frame than the one I walked in with." I said, "I know." He laughed. Not a polite laugh, a real one, the kind that comes out before you decide whether to let it. And then we kept talking until the afternoon session started and we had to go back inside, and when the session ended at 5:30 he exchanged cards with me in the lobby without making a production of it, just handed me his card and took mine and said it was good to think alongside someone for once, and I said it was, and we went to separate floors of the hotel and I sat in my room for 20 minutes thinking about the conversation before I called my mother and told her she had been right. He called me within 48 hours. I had been expecting it and also not entirely certain it would happen, which is the particular uncertainty of being 31 and having learned enough about the world to know that moments that feel significant do not always become the things they feel like they might become. But he called on the second day, in the early evening, and he said he had been thinking about something I said about the burden of proof and he thought I was right but he wanted to argue about it more and would I have dinner with him on Thursday. I said yes. We had dinner on Thursday. We had dinner again the following Tuesday. We argued about different cases and the same cases and adjacent cases, and sometimes we argued about things that had nothing to do with law, like whether it was better to know the names of birds or to simply appreciate them without knowing what to call them. Douglas said you appreciate things more when you know their names. I said you appreciate things more when you have to sit with not knowing and still find them beautiful. Neither of us ever conceded on that one. We were married 14 months later, at a courthouse on a Thursday afternoon, because we were both lawyers and we both found the efficiency of a courthouse wedding appropriate, and then we had dinner at a restaurant we liked with 6 people who were not offended by the informality of it, and it was the best Thursday I had ever had. Douglas's family never approved of me. I want to be precise about that because the word disapproved sounds like a polite thing, and what the Hartwells did was not polite. His mother, Margaret Hartwell, was a woman in her late 60s when I first met her, sharp-eyed and deliberate in her warmth, the kind of person who knows how to make you feel welcome while simultaneously making you understand that the welcome is conditional and she has the conditions. She told Douglas at Christmas dinner during our first year of marriage, while I was in the kitchen helping clear plates and could hear her clearly through the pass-through, that she did not understand what he saw in a woman who argued for a living. She did not lower her voice when she said it. I have always thought that was intentional. His brother Conrad was 3 years younger than Douglas and had built his sense of himself around being the more practical of the two, the one who handled the family finances after their father died, the one who made the arrangements and coordinated the logistics and kept Margaret from having to worry about things. He was not unintelligent. He was the kind of intelligent that knows how to identify the levers in a room and does not think too hard about whether pulling them is the right thing to do. He described me at a family gathering during our second year of marriage as the one who got her hooks in early, in a voice just loud enough to carry into the next room where I was standing, and when I walked in and looked directly at him he smiled and asked if I wanted a drink. His sister Patricia was the youngest and the quietest and therefore the one I watched most carefully. She had Douglas's quality of paying attention, but where Douglas paid attention because he was genuinely curious about the world, Patricia paid attention because she was gathering information. She smiled at me at every family event and said the right things and asked the right questions and reported the substance of every conversation back to Margaret by the following morning. I knew this not because anyone told me but because I am an estate litigation attorney and I have spent 17 years learning how families operate when there is something at stake, and the Hartwells were a family that always had something at stake. I knew all of this. I had known it from the first Christmas dinner, from the pulled punch of Margaret's disapproval delivered through a kitchen wall, from Conrad's particular brand of belligerence dressed up as humor. I had known it and I had made a decision early in my marriage that I was going to handle it the way I handle everything, which is to prepare carefully, document thoroughly, and never let anyone see me react before I am ready. I had also known, because I am an estate litigation attorney and I have spent 17 years watching families do to each other what money does to people, that the Hartwells were not going to wait long after Douglas died before they moved. I did not know the precise shape of what they would do. But I knew the category of it, the way you know the shape of a storm before you can see the clouds, just from the way the air feels and the particular quality of the silence before it arrives. What I had not predicted was how fast they would move. Or how certain they were that I would not see it coming. That was their first mistake. Their second was not knowing what I had already done 3 weeks before Douglas took his last breath, on a gray Tuesday afternoon when I sat in my own office after hours and prepared the filing that would make everything they were planning irrelevant before they ever set it in motion. Let me tell you about that Tuesday afternoon before I tell you about the Wednesday morning, because the Tuesday afternoon is where everything that matters actually begins. 3 weeks before Douglas died, I was sitting in my office at 7:30 in the evening after everyone else had gone home. I had been at the hospital that afternoon for 4 hours. Douglas had been asleep for most of it, the deep medicated sleep that had become the pattern of his days in the last month, the kind of sleep that is more like a tide going out than a rest. I had sat beside him and held his hand and watched the monitoring equipment and thought about what I was watching. The Hartwells had been at the hospital that week more than they had been in the previous 2 months combined. Margaret had been there every afternoon. Conrad had been there twice, which was twice more than he had come during the early months of the illness. Patricia had come on Monday and sat with Douglas for 2 hours while I was meeting with his medical team, and when I came back she smiled at me and said he had been peaceful and asked if I had eaten anything today. I said I had. She nodded and said good and gathered her things and left. I sat in the chair beside Douglas that afternoon and I watched his breathing and I thought about the 7-month-old family trust one had found in a research search I had run 6 weeks earlier, after a conversation with the hospice social worker had prompted me to review all the estate-adjacent entities connected to the Hartwell family. I had been doing my own quiet research for weeks, the kind of research that an estate litigation attorney knows how to do without leaving obvious traces of having done it. I had found the Hartwell family trust in the county records. It had been established 6 weeks after Douglas's first serious hospitalization. Its stated purpose was the management and preservation of family assets for the benefit of Hartwell family members. I am an estate litigation attorney. When I see a family trust established shortly after a family member receives a serious diagnosis, I know exactly what that means. It means someone in that family has already begun planning for what comes next. It means the planning has a specific direction. It means the assets are going to move if someone does not make sure they cannot. I sat beside Douglas until the light through the hospital window changed and then I kissed his forehead and told him I would be back in the morning and I drove to my office and I sat at my desk and I built the counterstructure that was going to make everything the Hartwells were planning fall apart before it ever got started. I began with the affidavit. The affidavit established the date and circumstances of Douglas's existing estate documents, which I had prepared myself in the first year of our marriage. I want to say something about those documents because they matter to understanding what came next. When Douglas and I decided to formalize our estate planning, in the second year of our marriage when we had begun to accumulate things worth planning for, I did not hire another attorney to draft them. I drafted them myself, with the same care I bring to documents I prepare for clients, which is to say I made them as clean and as difficult to challenge as I know how to make things. I had Douglas review every page in detail, not just sign at the designated lines, but actually read and understand the provisions, because I have seen too many estate disputes turn on a client who signed without reading and could not testify to what they had agreed to. I had him sign in front of 2 witnesses and a notary at the firm where I had been working before I opened my own practice. I kept the original in the firm vault and gave Douglas a certified copy for his own records. The documents were ironclad. I had made them ironclad on purpose, the same way I make everything I build on purpose, which is to say with the full understanding that someone might one day try to take them apart. What the affidavit did was create a time-stamped public record of those documents' existence and their contents, filed with the probate court, before Douglas died, before any competing claim could be made, before anyone could allege that the documents had been altered or fabricated after the fact. It was a preemptive strike in legal form, invisible to anyone who was not specifically looking for it, devastating to anyone who tried to file a challenge against documents that now had a court-stamped record of their existence predating any challenge by weeks. I also had a formal appraisal conducted on every major asset in the estate during that same window. The appraisals were clean and professional, and I filed them as part of the pre-death estate inventory that accompanied the affidavit. Anyone who later claimed assets had been manipulated or undervalued or moved was going to run directly into a publicly filed valuation record that existed before Douglas died, before the Hartwells made any move, before there was any dispute to speak of. I placed certified copies of everything in 3 locations. The firm vault. The safe deposit box that Douglas and I held jointly at a bank his family did not know we used, a small regional bank where we had opened an account in our first year of marriage because Douglas liked the branch manager and because having assets in multiple institutions was simply good financial hygiene. And in the hands of my associate Rosalind Park, who had been with my firm for 6 years and whom I trusted with anything I needed to trust with another human being. I finished the filings at 10:20 that evening. I drove home. I sat in the kitchen of the house on Alderton Lane and drank a glass of water and did not tell Douglas any of it, not because I was keeping secrets from him but because he was exhausted and because there was nothing he needed to do, nothing he needed to sign or review or worry about. The structure was already there. It had been there since the first year of our marriage. I had simply made it visible to the right people before anyone else could make it invisible. Then I went upstairs and sat in the chair beside Douglas's bed and listened to him breathe and told him about the sparrows I had seen in the parking lot of the hospital that afternoon, small gray birds on a wire, and asked him if he could tell me what kind they were. He was almost asleep. He said, "Sounds like juncos," and his voice was already far away. I said, "Are you sure?" And he said, "Dark-eyed juncos, they come through in November," and then he was asleep. 3 weeks later he died with the window open and the birds coming through, and I held his hand until it was still. I drove home from the cemetery on the afternoon of the burial and I sat in the kitchen for a long time. Douglas's family was still at the house when I left, which is to say they had come back after the burial to fill the house with food and conversation and the particular energy that grief and anticipation produce when they occupy the same room. Margaret had organized everything with the quiet efficiency of a woman who had been planning for this day for years, which, as it turned out, she had. There were casseroles. There were flowers that had been brought from somewhere. There were neighbors I barely knew standing in my kitchen with plates of food, doing the thing that people do when they do not know what else to do, which is bring more food and stand in the kitchen. I moved through it for 2 hours. I thanked people. I accepted their embraces. I told Conrad his suit was appropriate when he asked if it was appropriate, because it was a strange question to ask your dead brother's widow 4 hours after the burial, but Conrad was not always aware of the texture of the moments he was moving through. I watched Patricia watch me and I let her watch me, and I gave her nothing to report to Margaret except that I was composed and gracious and not showing anything she could use. Then I left. I said I needed to rest and I left, and I drove home and I poured myself a glass of water and I stood at the kitchen window and watched the last of the Hartwell cars pull out of the driveway, and then I let the house be quiet. My phone rang at 8:17 that evening. It was Conrad. He said, in the tone of someone who has rehearsed their lines and is satisfied with them, that he wanted to talk to me about the estate. He said Douglas had spoken to him about some of his wishes in his final weeks. He said he thought it would be better if we handled things as a family rather than through attorneys. He said, and this is the part one want you to remember because it is the most revealing sentence Conrad Hartwell ever directed at me, he said the Hartwells had always taken care of their own. The implication was clear. He was telling me that I was not one of their own. He was telling me that the estate was a Hartwell matter and that my role in it was being redefined, had perhaps already been redefined, and that the polite thing for me to do would be to accept that redefinition without requiring anyone to say it out loud. I told him I appreciated the call. I told him I would be in touch. I hung up and I held my glass of water and I thought about the filing I had made 3 weeks ago, and I thought about what Conrad thought he knew about my husband's estate, and I thought about the gap between those two things. that gap was everything. The call from Margaret came the following morning at 9. She had thought about the approach overnight and decided to come in softer than Conrad had, which meant Conrad had reported the outcome of his call and they had recalibrated. Margaret was warm in the particular way she was always warm with me, which is to say she wrapped the thing she actually wanted to say in enough courtesy that you had to hold it up to the light to see its shape. She said she had been speaking with Douglas in his final weeks about his wishes. She said he had expressed some concerns to her. She did not specify what concerns, about the estate documentation. She said she thought it would be wise for both of us to sit down with the family's attorney before anything moved forward. She said the Hartwells were not trying to be difficult, they were simply trying to honor Douglas's wishes, and she hoped I understood that. I told her I appreciated her reaching out. I told her I had already been in contact with my own attorney. I told her that the estate documentation was fully in order and that I was confident everything would proceed appropriately through the proper channels. I was professional and warm and I gave her absolutely nothing to work with. I hung up and called Rosalind. Rosalind said, "They have already contacted a probate attorney. His name is Stephen Holt. He filed a notice of appearance with the court this morning." I said, "I know Stephen Holt. We have appeared against each other twice." She said, "I know. They are claiming there is a codicil." I sat down at my kitchen table. A codicil is an amendment to a will. It is a legal instrument that can alter the distribution of an estate if executed properly, meaning with the requisite formalities, the signature of a testator with adequate cognitive capacity, proper witnesses, and proper notarization. If the Hartwells were claiming Douglas had executed a codicil in his final weeks, they were either fabricating the document entirely or they had obtained his signature during a period when his cognitive capacity was significantly compromised by medication and they were going to dress that up as a legitimate expression of his wishes. I said, "Is it filed?" Rosalind said, "Not yet. Stephen Holt submitted a notice of intent to file. They are claiming it was executed 6 weeks before Douglas died. 6 weeks before Douglas died he had been on a palliative medication protocol that I had watched alter his relationship to complex information in real time. He had known who I was. He had recognized his family. He had asked me about birds. But his ability to track sequential legal reasoning, to read a document and understand not just its words but its implications, to give what the law calls informed consent to a complex instrument, had been significantly compromised by what the medication did to his cognitive processing speed. Anyone who had spent more than 20 minutes with him during that window would have known it. I said, "Pull the hospice records. Every visit, every medication log, every nursing note from the 6-week window before he died." Rosalind said, "Already requested." I said, "Good." I ended the call and poured my water down the drain and made coffee and sat at my kitchen table with a legal pad and began building the case. Not the case I was going to have to build in response to a challenge that had not yet been filed. The case I was going to walk into the probate court within approximately 11 business days, fully assembled, every piece in its place, nothing improvised, nothing reactive. I had been preparing for 3 weeks. I was not starting from zero. But I did not know, not yet, what I found out on the 4th day after Douglas's burial when I called a man named Frederick Alden. Frederick Alden had been Douglas's law partner for 30 years. They had built their corporate transactional practice together from a 2-person firm in a rented office above a dry cleaner into a respected mid-sized practice with 12 attorneys and a client list that included 3 regional banks and 2 publicly traded companies. Frederick was 71, sharp-minded, and the kind of man who thought carefully before he spoke and then said exactly what he meant without ornamentation. He was the person Douglas had called when something mattered. He was also the person Conrad had called the week after Douglas died, believing that 30 years of professional partnership and shared history would translate into a statement supporting the Hartwell family's account of Douglas's final wishes. Conrad did not know Douglas as well as he thought he did. I called Frederick on the 4th morning after the burial. He picked up on the 2nd ring. I told him who I was, though he knew me well enough that the introduction was a formality. I told him what the Hartwells were claiming. I told him about the codicil. Frederick was quiet for a longer moment than I expected. Then he said something that I wrote down on the legal pad in front of me because I knew I was going to need it. He said, "Sylvia, Douglas called me 8 weeks ago. He told me his family was going to make a move after he died. He said he was not certain of the form it would take, but he was certain it was coming. He told me that if anyone contacted me claiming he had changed his estate documents in his final weeks, I should call you immediately and tell you that he had done no such thing, and that whatever they were claiming did not reflect anything he had actually expressed to me." I held the phone and I did not say anything for a moment. He said, "I am sorry I did not call you first. I was not certain it was my place." I said, "You are calling now. That is what matters." Even dying, Douglas had seen it coming. He had called his closest professional ally 8 weeks before his death and told him what was going to happen and asked him to be ready to say so. He had done this without telling me, possibly because he did not want me to have to carry the knowledge during the last weeks we had together, possibly because he trusted me to have already prepared, which I had. Douglas paid attention to things. He had paid attention to me for 11 years. He knew what I was capable of. He had seen it coming and he had trusted me to handle it, and he had set up his own small piece of the counterstructure without making a production of it, because that was also who Douglas was. I closed my eyes for a moment. Then I opened them and looked at my legal pad. I had the original estate documents. I had the pre-death affidavit filed with the probate court. I had the estate inventory. I had the asset appraisals. I had Rosalind requesting the hospice medical records. I had Frederick Alden, who could testify to what Douglas had told him 8 weeks before his death. What I did not have yet was what I found out on the 7th day, when Patricia Hartwell called me at 11 in the morning and asked if she could come by the house. I said yes. I want to tell you what it felt like to open my front door and see Patricia standing on my porch, because I think it is important. Patricia Hartwell had spent 11 years treating me with the precise civility of someone who has decided you are an inconvenience and has also decided to be impeccably polite about it. She had never been cruel to me directly. She had been something more sophisticated than cruel, which is to say she had been perfectly courteous and had made absolutely certain I understood that her courtesy was a performance rather than a feeling. Standing on my porch that morning, she looked like a woman who had been carrying something for too long and had made a decision about it. She sat across from me at the kitchen table and she put her hands flat on the table and she said, "Sylvia, I need to tell you something, and I need you to understand that I am telling you because it is the right thing to do and not because I am disloyal to my family." I told her I was listening. And she told me everything. She told me she had been present when Conrad brought the codicil to Douglas for signature. She told me Douglas had been asleep when Conrad arrived. She told me Conrad had woken him, gently, and told him there was a document that needed his signature, a formality about the trust, nothing complicated. She told me Douglas had asked twice what he was signing, not in the voice of a man who was suspicious but in the voice of a man who was very tired and was trying to track something his brain was not moving fast enough to fully process. She told me Conrad had said it was just a formality, just something that needed to be in order, and Douglas had signed it without reading it because he was exhausted and because he trusted his brother and because the medication made sustained reading feel like trying to walk through water. She said, "He didn't know what he signed, Sylvia." I was standing at the foot of the bed and I watched him sign it and he didn't know. She looked at me across the table and what I saw in her face was not guilt exactly but something adjacent to it, the expression of someone who had been telling themselves a sufficient story about a decision and had finally run out of road. She said, "I told myself Conrad was doing it for the family. I told myself Douglas would have wanted it. I have been telling myself that for 6 weeks and I cannot do it anymore." I said, "I hear you." I said, "What you have shared is significant." I said, "I am grateful that you came." I did not tell her everything I already had. I did not need to. What Patricia had just given me was the direct eyewitness account of the codicil's execution by a member of the Hartwell family itself, someone who had been in the room, someone who could testify under oath that the execution did not meet the standard of an informed, voluntary, competent signing. The Hartwells had built something that looked like a legal instrument. They had built it carefully, with an attorney who was not going to make elementary mistakes. But they had built it in a room where Douglas had asked twice what he was signing and been told not to worry about it, and one of the 3 people in that room had a conscience that proved stronger than her family loyalty. That was the thing they had not accounted for. Not my preparation, not the pre-death filing, not Frederick Alden. They had not accounted for the possibility that someone who loved Douglas and also knew what she had witnessed was going to find, 6 weeks later, that she could not continue to live inside the story she had been telling herself about it. The codicil was not going to survive what was coming. I knew it on day 7 with absolute certainty. What I could not have told you on day 7 was what I learned on day 8, when I began looking into the notary who had authenticated the document, a woman named Barbara Kern. Barbara Kern had been a notary in this county for 19 years. She had a clean record in the public database. But I had seen her name once before, in a case file from 8 years ago, a fraudulent instrument matter I had litigated for a client whose estate had been challenged on the basis of a suspicious amendment. That case had settled before it reached a hearing, but the settlement included a detailed record of the professional conduct concerns that had been raised about the notary's attestation process. That record was not a conviction. It was not a license revocation. But it was a document in a court file in this jurisdiction, and it put her professional judgment in a specific historical context that was going to be very relevant to any court evaluating her attestation of a document signed by a man on palliative medication. I pulled the file. I had the case number in my archived records. I printed the relevant sections and added them to the stack. By the end of day 8, I had the complete architecture of the response. I had the original estate documents. I had the pre-death affidavit with its court timestamp. I had the estate inventory and appraisals. I had the hospice medical records, which had arrived from the organization on day 6 and which I had spent 4 hours reviewing with Rosalind. I had the opinion of Dr. Andrea Solis, Douglas's palliative care physician, who I had reached on day 7 and who had agreed, after reviewing the medication logs for the relevant window, to provide an expert statement on the cognitive effects of the protocol Douglas had been on at the time the codicil was allegedly executed. I had Frederick Alden's written statement. I had Patricia Hartwell's signed and notarized account of the execution. I had the Barbara Kern professional conduct documentation. And I had the filing I had made 3 weeks before Douglas died, sitting in the probate court records, timestamped in public, predating every move the Hartwells had made by 21 days. I contacted Stephen Holt's office on day 8 and requested a pre-hearing conference for the following week. I did not tell him what I was bringing. I told him I wanted to discuss the timeline of the codicil's execution in light of the medical record evidence I had obtained. Stephen Holt agreed to the conference. He sounded like a man who believes he is walking into a manageable negotiation. That sound would not last long. I put down the phone and looked around the kitchen of the house on Alderton Lane. Douglas had chosen the color of these walls, a particular shade of gray-green that he said looked like light through leaves, which is an exact and accurate description of what it looks like on a clear afternoon. The furniture in the living room was his too, chosen piece by piece over the first years of our marriage with a care and attention I had found quietly astonishing in a corporate transactional lawyer who appeared to most of the world as nothing more than methodical and precise. He had known what birds were outside the hospital window and he had chosen walls the color of light through leaves and he had called Frederick Alden 8 weeks before he died to make sure someone was ready to tell the truth if the truth needed telling. I had not let that trust land on empty ground. I stood in his kitchen with the pre-hearing conference scheduled for a Tuesday morning at 10 and I let myself understand, for the first time since the Wednesday he died, that what was coming was not a fight I might lose. It was a conclusion I had already written. It was a case I had already built. All that remained was delivering it. I made dinner. I ate it at the kitchen table. I went to bed at a reasonable hour for the first time in 3 weeks. Tomorrow I would start preparing for Tuesday. The Hartwell family moved the way I had expected them to move, which is to say efficiently, confidently, and without the caution that comes from believing your opposition might know what you are doing. That absence of caution is the most expensive mistake a person can make when they are walking into a legal dispute with someone who has spent 17 years in exactly that arena. They did not know what I did for a living. That sounds impossible given that I was Douglas's wife for 11 years, but the truth is that the Hartwells had never been interested in me as a person. They had been interested in me as a problem. And when you reduce someone to a problem, you stop gathering information about them. You stop updating your picture of who they are. You walk into the fight with a map that was last drawn years ago and you do not check whether the terrain has changed, because you have already decided the terrain is the same terrain it always was, and the person standing in the middle of it is the same person they always were, and the outcome is the one you have already decided on. That is a very expensive way to approach a legal proceeding. The Hartwells were about to find out exactly how expensive. Let me tell you about Margaret Hartwell, because I want to be precise about her, the way I try to be precise about all the antagonists in the cases I litigate, not because precision is kind but because imprecision is inaccurate and inaccuracy is a professional failing I do not permit myself. Margaret was a formidable woman. I want to give her that without reservation. She had raised 3 children mostly alone after Douglas's father died young, when Douglas was 14 and Conrad was 11 and Patricia was 8, in circumstances that would have broken many people, managing a household and a grief and 3 children with different needs and different ways of processing loss with an efficiency and a steadiness that I genuinely respected when I examined it without the overlay of what she had done to me. She had managed the family finances with genuine competence through that period, had made decisions that preserved what little capital her husband had left behind, had seen her children through school and into careers without asking anyone for help that she was not prepared to eventually repay. That history had built in Margaret a kind of loyalty to her children that was so total and so long-standing that it had calcified into something that could no longer distinguish between protecting them and harming others on their behalf. She did not experience what she was doing to me as harm. She experienced it as retrieval. She believed, with a sincerity I think was genuine rather than performed, that the estate Douglas had built over his professional lifetime was Hartwell family wealth, that it had its origins in the family's history and its foundation in the character Douglas had developed within the family she had built, and that I was a woman who had come into his life at 38 and attached herself to 11 years of that wealth and who should not be permitted to extract it now that the man himself was gone. The fact that Douglas had chosen me specifically and deliberately and with full information, that he had loved me with the same attentive care he brought to everything he valued, was information Margaret had processed once and then quietly set aside because it did not fit the version of the story she had been telling herself since the Christmas dinner when she said she did not understand what he saw in a woman who argued for a living. I understood her motivation. I want to be clear about that, because understanding an opponent's motivation is not the same as forgiving the action it produced, and I am not in the business of performing forgiveness for things that have not earned it. But understanding Margaret meant I was never surprised by her, never caught off guard by the specific shape of what she did, because I had been reading her clearly from the first year of the marriage and she had not given me any reason to revise the reading. Conrad was simpler and in some ways more dangerous for his simplicity. He had spent 3 decades believing he was the practical one, the one who handled things while Douglas provided the professional prestige and Margaret provided the emotional center of gravity. He managed the family's minor investments. He coordinated the logistics of family events. He was the one who researched the hospice options when Douglas's diagnosis became unambiguous and presented the findings to the family in a manner that telegraphed his own importance to the process. He was the kind of man who experiences the management of other people's crises as a form of power, and who had spent enough years in that role that the line between managing a situation and controlling it had become invisible to him. When Rosalind called me on the 4th morning and told me Conrad had also contacted Douglas's former law partner, I understood immediately what Conrad thought he was doing. He thought he was building a coalition. He thought Frederick Alden, 30 years of professional loyalty to Douglas, shared history and shared cases and the particular bond of 2 men who had built something together over decades. He thought all of that would translate into Frederick standing with the Hartwell family's account of Douglas's final wishes. He thought Frederick would be the anchor witness, the one whose professional credibility and long relationship with Douglas would make the codicil's alleged origins plausible to a probate court. Conrad had not called Douglas once in the 8 weeks between Douglas's phone call to Frederick and the day Douglas died. Douglas had told me this himself, in one of the evenings when we sat together and he was lucid and the conversation moved into the territory of his family and what he expected from them and what he had stopped expecting. He said Conrad called when he needed something and did not call when he did not. He said this without bitterness, which was very Douglas, observing the fact of a thing without adding editorial weight to it. He said Conrad would come after he died. He would come with his management instinct and his certainty that he knew what Douglas would have wanted, and that what he would want would happen to align perfectly with what was best for the Hartwell family interests. I said, "And you are all right with that?" Douglas said, "I am all right with knowing that you will handle it." He said it simply, the way he said things that he was certain of, without flourish or qualification. Then he closed his eyes and was quiet and I sat beside him and the room was still. I had been all right with that. I had been handling it for 3 weeks before he died. The codicil itself was a professionally drafted document. I want to give Stephen Holt his due on that point because accuracy demands it. He had constructed it carefully, with the right language in the right order, the provisions presented in a logical sequence that moved from the general statement of intent to the specific asset designations without the kind of structural awkwardness that flags a document assembled in haste. The court claim was that Douglas, in the final weeks of his life, had expressed a desire to ensure that assets accumulated during the marriage were preserved for the benefit of the Hartwell family line, and that this codicil reflected that expression. The language was careful. It did not say Douglas had concerns about me specifically. It did not allege misconduct. It implied, in the way that legally careful language implies things rather than states them, that there was some uncertainty about the fate of the assets under the existing documentation and that this codicil was Douglas's remedy for that uncertainty. It was a well-constructed instrument. What it was not was a document that could survive the scrutiny of everything I had already assembled. Rosalind called me the morning the notice of intent to probate was filed, day 5 after the burial, and read me the key language. I listened to all of it. Then I asked her to read me the date of execution one more time. 43 days before Douglas's death. I sat with that number. 43 days. I pulled the hospice medication log I had already been reviewing and I counted backward from the date of Douglas's death. 43 days before his death put the alleged execution at a point in the palliative protocol when his medication had been adjusted twice in the preceding week in response to increased pain levels, adjustments that the nursing notes described as producing significant sedation effects and measurably affecting his ability to retain sequential information. The nursing notes from the day of the alleged execution included a notation from the afternoon visit that Douglas had asked the visiting nurse what day it was, which was not unusual, and had then asked again 40 minutes later, which was also noted as consistent with the medication effects the team had been observing. A man who could not reliably retain the day of the week was not a man who could give informed consent to a complex legal instrument that altered the distribution of his estate. That was the argument. It was not a dramatic argument. It did not require rhetorical elaboration. It required documentation, and I had the documentation. What I was still assembling in those first days was the expert framing. The medical records were facts. What I needed was an expert who could translate those facts into the language that a probate court requires, the clinical language that establishes not just that a patient was on medication but that the specific medication and the specific dosage at the specific time of the alleged execution would have produced specific effects on the cognitive capacities relevant to legal consent. That expert was Dr. Andrea Solis. I called her on day 7, the same day Patricia came to my kitchen table. I reached her at her clinic between appointments. I told her what I needed. I told her the date of the alleged execution and the medication log entries for that day. She was quiet for a moment, the particular quiet of a physician who is reviewing clinical information mentally before speaking. And then she said she would need to review the full chart before she could provide a formal opinion, but that based on what I had described the protocol Douglas had been on at that point in his treatment would have produced measurable effects on his ability to process and retain complex sequential information, and that she would be prepared to explain those effects in detail in a written expert statement. I thanked her. I told her Rosalind would be in touch with the formal request. She said that was fine. Then she said, and I appreciated this, she said, he was a remarkable person to care for, Sylvia. He asked about your work every time I visited. He wanted to know what cases you were working on. He said you were the best attorney he had ever seen, and he had seen quite a few. I said, he was generous in his assessments. She said, he was accurate in his assessments. There is a difference. I said I thought that was right. Then I thanked her again and ended the call and sat at my desk for a minute before moving on to the next item on the list. There is something I want to tell you about the experience of those days that is not about the legal mechanics, because the legal mechanics are important, but they are not the whole of what I was living through. I was building a case and I was also grieving. Those two activities were happening simultaneously in the same body and the same mind, and they were not always compatible. There were moments in those 11 days when the grief would rise up in the middle of something technical, in the middle of reviewing a medication log or drafting a letter to Stephen Holt's office, and I would have to stop and acknowledge it and then set it aside again because there was more work to do. That is not a healthy way to grieve. I knew it was not healthy. I also knew that the work was the thing that was keeping me functional in those days, and that the grief would still be there when the work was done, which it was, and which it still is. Douglas had trusted me to handle it. I was handling it. The grief could wait in the room beside the one I was working in. It was patient. It knew I would come back to it. On day 9 I had a conversation I had not expected to have, which is to say a conversation that had not been on my list of things to prepare for. It came from an unexpected direction, the way things sometimes do when a situation has more dimensions than you originally mapped. Margaret called me. Not through Stephen Holt, not through any intermediary, but directly, her own voice on my phone at 2 in the afternoon on day 9. She asked if she could speak to me personally, outside the formal process, woman to woman, and her voice had a quality I had not heard in it before, something that was not quite softness but was adjacent to it, the quality of someone who has begun to understand that the ground beneath them is not as solid as they believed. I said I was willing to listen. She said, Sylvia, I want you to understand that nothing we have done has been intended as an attack on you personally. She said, Douglas was my son. She said, I carried him. I raised him. I sat up with him when he had fever as a child and I watched him become the man he was, and I cannot simply hand the things he built to someone who knew him for 11 years when I have known him his entire life. I listened to all of it. I did not interrupt. When she finished I said, Margaret, I understand what you are telling me. I understand that what you have done comes from love for Douglas. I want to tell you something that I believe is true, which is that Douglas knew his family was going to move after he died, and he chose not to spend his last weeks in conflict with you because he loved you and did not want those weeks to be defined by conflict. He spent those weeks letting you be present with him. He allowed that. He chose it. What he also did, 8 weeks before he died, was call Frederick Alden and tell him exactly what was coming and what to say if it did. And 3 weeks before he died, I filed the documentation that makes what you have built impossible to sustain in court. Not because I am your enemy, Margaret. Because Douglas trusted me to protect what we built, and I am not going to let that trust be dishonored. The line was quiet for a long moment. She said, he told Frederick? I said, he did. Another silence. Then she said, how long have you known what we were doing? I said, long enough to prepare before you moved. She said nothing after that. Not for a long enough moment that I began to wonder if the call had dropped. Then she said, very quietly, he really didn't tell you about the birds until he was almost gone, did he? He told me about the birds in October, about wanting to hear them, and I thought it was just something he said. I said, he told me the night before. I left the window open. Another silence. Then she said, I will speak to Conrad. I said, Stephen Holt has my contact information. She said, I know. She ended the call. I sat with the phone in my hand for a moment and I felt the grief come up again, closer to the surface than it had been all day, Because Margaret had said the word son in a voice that held everything she meant by it, and whatever she had done, whatever the Hartwells had attempted, she had loved Douglas in her particular total way, and he was gone, and that was real, and it was not nothing. I set the phone down. I went back to the legal pad. Day 10 I spent reviewing the full response package with Rosalind. We went through every document in the order I planned to present it. Rosalind flagged 2 places where the citation to the medication log could be cleaner and I revised them. She flagged 1 place where the language of the Patricia statement could be strengthened with a specific reference to the date of the execution and the time Conrad had arrived, and I called Patricia and asked for that clarification and she provided it without hesitation, calling me back within 20 minutes with the precise information, the date, the time, what Douglas had been wearing, what the light was like in the room, the details that only someone who was actually there would carry. I added those details to the statement. Then I printed the full package and sorted it into a clean folder and set it on my desk and looked at it. Everything the Hartwells were going to walk into that conference room expecting to resolve in their favor was in that folder. Every assumption they were making about what I had and what I knew and what I was capable of was going to encounter that folder on a Tuesday morning at 10 o'clock, and the distance between their assumptions and the contents of that folder was the distance between what they believed they had and what they actually had, which is to say the distance between something solid and something hollow. They believed they had a legally executed amendment to Douglas's will, authenticated by a notary, supported by family testimony, drafted by a competent attorney, representing a legitimate change of intention by a man who had the right to change his mind about his estate. What they actually had was a document signed by a man who had asked twice what he was signing and been told not to worry about it, authenticated by a notary with a professional conduct matter in her history, in a room where one of the 3 people present had decided she could not live with what she had witnessed, drafted by an attorney who did not know that his opposing counsel had been preparing for this proceeding for 3 weeks before the testator died. And behind that document, filed in the probate court 3 weeks before Douglas drew his last breath, was everything I had already put in place. I closed the folder. I made dinner. I sat at the table in the house that Douglas had loved and I talked to him the way I had been talking to him in the evenings since he died, not out loud, just internally, the kind of conversation that is really just thinking but that feels like more than thinking when you are doing it with someone who is no longer there to answer. I told him I was ready. I told him the birds he heard that morning were dark-eyed juncos. Then I went to bed and I slept for the first time in 10 days with something that felt, if not exactly like peace, then at least like the settled certainty of a person who knows exactly what she is walking into tomorrow and has done everything in her power to be ready for it. The pre-hearing conference was Tuesday morning at 10. I arrived at 9:48. The conference room Stephen Holt's firm used for pre-hearing meetings was on the 14th floor of a building downtown that had been built in the era when law firms wanted their offices to communicate permanence and weight. Dark wood paneling. A long table with enough chairs for more people than were ever actually present at these kinds of meetings. Windows that looked out over the city in a way that was designed to remind anyone sitting across from the firm's attorneys that the firm occupied a position of height, literally and figuratively, relative to whatever problem had brought you to this room. I had been in rooms like this hundreds of times in 17 years of practice. They had stopped impressing me approximately 16 years and 11 months ago. I arrived 12 minutes early. Rosalind was with me. We set our materials at one end of the table, not spread out to demonstrate volume, simply placed in the order I intended to present them, which is a different thing. A stack of documents presented in order communicates something specific to the person who is about to receive it, not chaos, not aggression, but precision, the particular precision of someone who has thought carefully about sequence and causation and has organized their evidence to reflect that thinking. I have learned over 17 years that precision is more frightening to an unprepared opponent than volume. Volume suggests you have gathered everything you could find. Precision suggests you have gathered exactly what you need and you know the difference. We did not speak much while we waited. Rosalind and I had been working together long enough that the silences between us in professional settings were not uncomfortable. They were simply the absence of words in a situation where words were not yet needed. She reviewed her notes. I looked at the window and the city beyond it and thought about the order of presentation one more time, not because I was uncertain about it but because final review is a professional habit I do not abandon even when I am confident. Conrad Hartwell and Stephen Holt arrived at 10:03. Conrad walked in the way he always walked into rooms, with the energy of a man who has pre-decided that the room is his, that the situation is manageable, that the outcome is a matter of execution rather than uncertainty. He looked at me when he entered and he gave me the particular look I had seen him give me across family dinner tables for 11 years, the look that said he had categorized me and filed the category and was not expecting anything from me that would require him to revise it. He nodded at me the way you nod at a person you have already processed. Then he took his seat and arranged himself and looked at Stephen Holt as though the two of them were the principals of the meeting and Rosalind and I were a logistical element to be dealt with. Stephen Holt was more careful. He had appeared against me twice before and he knew enough to be careful. He was a man in his late 50s who had built his practice on estate litigation and probate disputes, which meant he was experienced and organized and not given to underestimating the preparation on the other side of the table. What he did not know was the specific extent of what was on the other side of the table today, because I had not told him. I had told him I wanted to discuss the timeline of the codicil's execution in light of the medical record evidence I had obtained, which was true and was also the minimum amount of information required to get the meeting scheduled. Stephen Holt was walking in expecting a discussion about medical records. He was not walking in expecting everything else. He greeted me professionally, by name, with a handshake that communicated the particular respect of two opposing attorneys who have dealt with each other before and have formed a mutual assessment that the other is competent. He greeted Rosalind. He sat down. He arranged his own materials, which were organized and clean in the way that a prepared attorney's materials always are. Then he looked at me and said he was glad we could meet before the formal hearing and that he hoped we could find a productive path forward. I said I hoped so too. He said he would like to begin by presenting the Hartwell family's position and the basis for the codicil, and that he thought once we had reviewed the document and its supporting attestation we could have a useful conversation about next steps. I said that was fine. Stephen Holt presented the codicil cleanly and in order. He outlined its execution, the date, the circumstances as the Hartwell family had described them, Douglas in a period of relative lucidity expressing a considered wish about the disposition of his estate, a wish the family had taken careful steps to document properly. He outlined the Hartwell family trust and its purpose, the preservation of family assets for the benefit of Hartwell family members. He outlined the family's position that the codicil represented a legitimate and properly executed amendment to Douglas's existing estate documents, and that the existing documents, while valid at the time of their original execution, had been superseded by this later expression of intent. He was thorough and he was professional, and the case he presented, taken on its own terms without the context I was about to introduce, was not obviously flawed. That is the thing about a well-drafted fraudulent instrument. It does not look fraudulent from the outside. It looks like a document. It has all the pieces a document is supposed to have. The problems are in the things underneath the surface, in the circumstances of the execution, in the history of the people who participated in it, in the records that tell a different story than the one the document presents. Those things are not visible in the document itself. You have to know where to look for them, and you have to have already looked. Stephen Holt finished. He looked at me across the table. I said, "Thank you. I appreciate the thorough presentation. I would like to respond, and I want to be direct with you about what I have, because I think directness is going to serve everyone at this table better than a prolonged negotiation about positions that are not going to move." He said, "Please." I placed the first document on the table. I slid it across to him without comment. He picked it up and began reading it. It was the certified copy of the affidavit I had filed with the probate court 3 weeks before Douglas died, with the court's filing timestamp clearly visible on the face of the document. It established the date and circumstances of Douglas's original estate documents and cross-referenced those documents against the certified copy I had filed alongside it. Stephen Holt read it carefully. He did not show Conrad what was in his face while he read it, which was professional of him, but I was watching and I saw the particular stillness that crosses a prepared attorney's expression when they encounter something they were not expecting and are rapidly recalibrating. He set it down. He looked at me. He said, "You filed this before Douglas died." I said, 21 days before. It is a public record. The case number is on the face of the document. Conrad leaned forward and reached for the affidavit. Stephen Holt let him take it. Conrad read the first page. His expression did not change immediately, which I will give him credit for, but his hand tightened slightly on the edge of the paper in a way that told me he understood what he was looking at. I placed the second document on the table. The pre-death estate inventory, with the accompanying asset appraisals. I said, 3 weeks before Douglas died, I also commissioned a formal appraisal of every major asset in the estate and filed the results as part of the pre-death inventory. The filing predates any claim that assets were manipulated, undervalued, or moved after Douglas's death by 21 days. Stephen Holt picked up the inventory. He reviewed the index page. He set it down. I placed the third document on the table. The hospice medical records, tabbed to the relevant sections. I said, the codicil claims to have been executed 43 days before Douglas's death. The medication log for that date shows that Douglas was on a palliative protocol that had been adjusted twice in the preceding week in response to increased pain levels. The nursing notes for that day include 2 separate notations documenting instances where Douglas was unable to retain sequential information within the same visit. The specific notation from the afternoon of the alleged execution documents a conversation in which Douglas asked the visiting nurse what day it was and then asked again 40 minutes later. I paused. I said, a man who cannot reliably retain the day of the week is not a man who can give legally valid informed consent to a complex estate instrument that redirects the distribution of his primary assets. That is the standard. The medical records establish that Douglas did not meet that standard on the date the codicil was allegedly executed. Stephen Holt was reading the tabbed sections. Conrad was very still across the table. I placed the fourth document on the table. Dr. Andrea Solis's written expert statement. I said, this is the expert opinion of Dr. Andrea Solis, who was Douglas's palliative care physician and who supervised the medication protocol he was on during the window the codicil claims for its execution. Dr. Solis has reviewed the full chart and the specific medication log for the date in question. Her statement addresses the cognitive effects of the protocol on Douglas's capacity to process and retain complex sequential information at that point in his treatment. It is her expert clinical opinion that Douglas's capacity to give informed consent to a complex legal instrument on the date of the alleged execution was materially compromised by the effects of the palliative medication protocol. I let Stephen Holt read the first page of the statement. I gave him time. I did not rush the presentation because rushing is what you do when you are not confident in what you are presenting, and I was entirely confident in what I was presenting. Then I placed the fifth document on the table. I placed it a little more slowly than the others. Not for effect, I want to be clear about that. I do not use effect in these settings because it is imprecise and imprecision is a professional failing I do not permit myself. I placed it slowly because it was the document that required the most care in handling, not because it was fragile but because of what it represented. It was Patricia Hartwell's signed and notarized statement. I had asked Patricia, when she provided the additional details Rosalind had flagged, whether she was prepared to have the statement notarized, and she had said yes without hesitation. I had sent a mobile notary to her home that same afternoon. The statement was properly executed in every respect. I said, this is a sworn statement from Patricia Hartwell, who was present in the room on the date the codicil was allegedly executed. It describes the circumstances of that execution in detail. Patricia states that Douglas was asleep when Conrad arrived and that Conrad woke him. It states that Douglas asked twice what he was signing and was told it was a formality about the trust. It states that Douglas signed the document without reading it. It states that in Patricia's direct observation, Douglas did not understand the nature of what he was signing at the time of execution. The room was quiet. Conrad looked at the document. He looked at it for a long time. Then he looked up and across the table, and when he looked at me his expression had changed in a way that I did not experience as victory. I want to be precise about that too. I have never experienced a moment like this one as victory, because what I am doing in moments like this one is not winning. It is correcting something that should not have been allowed to stand. But I will tell you what I saw in Conrad's face in that moment. I saw the particular look of a man who has walked into a room certain of his position and has discovered that the position was built on a set of assumptions that are no longer operative. It is a specific look. I have seen it across tables before. It is not anger, exactly, though anger is adjacent to it. It is the look of someone whose map and the territory have come apart. He said, Patricia had no right. I said, she had every right. She was a witness to an act of fraud and she chose to report it accurately. That is not a betrayal of your family, Conrad. That is an act of legal and moral integrity. The two things are not incompatible, though I understand that from your current position they may feel that way. He said, she was supposed to be family. I said, she is family. She is Douglas's sister. She loved him. What she could not do was continue to live with what she had watched happen in that room, and I think if you reflect on it honestly you will understand that the version of loyalty you are describing, the loyalty that requires her to stay silent about what she witnessed, is not loyalty at all. It is something else. Conrad looked away from me. He looked at Stephen Holt. Stephen Holt was not looking at either of us. He was looking at the documents arranged in front of him, moving between them with the focused attention of an attorney who is rapidly and accurately assessing what they mean for the position he has been retained to advance. I placed the sixth document on the table. The Barbara Kern professional conduct documentation. I said, the notary who authenticated the codicil is a woman named Barbara Kern. She has been a notary in this county for 19 years. She also appears in a court file from 8 years ago, a fraudulent instrument matter I litigated for a client in this jurisdiction, in which concerns were raised about the professional judgment she exercised in attesting a document whose execution circumstances were disputed. The case settled before hearing, but the professional conduct concerns and the factual record of that matter are in the file, and the file is public record. I can provide the case number if you would like to pull it. I paused. I said, I am not alleging that Barbara Kern committed notarial fraud in this matter. I am noting that her professional history in this jurisdiction includes a documented instance of disputed attestation judgment, and that a court evaluating the authenticity and procedural integrity of the codicil will have access to that history. Stephen Holt set down the document he had been reviewing. He looked at me with the expression of an attorney who has just completed a rapid and accurate assessment and has arrived at a conclusion he does not enjoy but cannot dispute. He said, I would like to request a brief recess to confer with my client. I said, of course. He and Conrad stood. They went into the hallway. The door closed behind them. I could not hear what they were saying, which was appropriate. It was a privileged conversation and I had no interest in its contents. I knew what its contents were. Stephen Holt was walking Conrad through the assessment that any competent attorney would make after reviewing what I had just put on the table. He was explaining what the pre-death affidavit meant for their ability to claim the existing documents had been manipulated. He was explaining what Dr. Solis's expert opinion meant for their ability to argue Douglas had adequate cognitive capacity at the time of execution. He was explaining what Patricia's statement meant for the credibility of their account of the execution circumstances. He was explaining what the Barbara Kern documentation meant for the reliability of the attestation. And he was explaining, with the directness that a competent attorney owes his client in a moment like this one, what the likely outcome of a formal probate hearing was going to be if they chose to proceed. Rosalind and I sat at the table. We did not speak. The window showed the city in the flat gray light of a November morning, and I looked at it and thought about Douglas choosing the color of his kitchen walls to look like light through leaves, and I thought about the Tuesday evening 3 weeks before he died when I sat at my desk after hours and began building this, and I thought about the 40 minutes I had sat beside him after the nurse left and the birds outside the window and the particular quiet of a room where someone has just left it for good. They were gone for 14 minutes. I know it was 14 minutes because I looked at the clock when they left and I looked at it again when the door opened. Stephen Holt came back in first. He sat down. He placed his hands on the table in front of him, not on his documents, just on the table, which was a small physical signal that told me he had shifted from presentation mode to negotiation mode. Conrad came in behind him and sat down and did not look at Patricia's statement again. He looked at the window instead, the same window I had been looking at, the city in November light. Stephen Holt said, "I would like to explore whether there is a framework for resolution that does not require a formal hearing." I said, "I am open to that exploration." He said, "The Hartwell family is prepared to consider a withdrawal of the codicil in exchange for certain assurances regarding the administration of the estate." I said, "Tell me what assurances." He outlined them. They were not unreasonable in structure. They were the kind of conditions that a family in this position asks for when they have realized their primary instrument is not going to hold and they are trying to salvage something from the negotiation. Involvement in the estate administration process. Notification of major decisions regarding estate assets. A formal acknowledgement that the Hartwell family's concerns about Douglas's wishes had been heard and considered. I let him finish. Then I said, "I will tell you what I need, and then you can tell me whether we have a framework." I said, "The withdrawal of the codicil must be unconditional and in writing, with no reservation of the right to bring a future challenge on the same grounds." I said, "The stipulation confirming the validity of the original estate documents must include language specifying that those documents reflect Douglas's genuine and informed wishes as expressed at the time of their original execution." I said, "I will need a full accounting of any administrative actions taken regarding estate assets since Douglas's death, including any transfers, notifications, or filings made in the name of the Hartwell Family Trust that touch the assets named in the codicil." I said, "Any assets that have been moved in the interim period must be returned." Stephen Holt made notes. He did not push back on any of the items I had listed, which told me he had anticipated most of them and had already assessed them as within the range of what his clients would accept. Then I said, "There is one additional requirement." He looked up. I said, "The withdrawal and the stipulation are conditional on a written acknowledgement, signed individually by Margaret, Conrad, and Patricia Hartwell, that Douglas's estate documentation as originally executed reflects his genuine and informed wishes. I do not require that acknowledgement to be a public document. I do not require it to be filed with the court. But I require it to exist, to be executed with the same formality as the stipulation, and to be held in my possession." Stephen Holt was quiet for a moment. He said, "You want Margaret's signature on that document?" I said, "I want all three of them." "But yes. Margaret's signature in particular." He said, "I understand. I will need to discuss this with my clients." I said, "I will expect to hear from you within 48 hours. If I do not hear from you in 48 hours, I will proceed with the formal competency challenge at the scheduled hearing, and I will present everything currently on this table to the probate court, together with Frederick Alden's written statement, which I have not yet shown you and which I believe you will find relevant." Stephen Holt's expression shifted very slightly at the mention of Frederick. Not dramatically, not visibly enough that Conrad, who was still looking at the window, would have noticed. But I saw it, the small recalibration of someone who has just been informed that there is another piece they did not know about. He said, "Frederick Alden." I said, "Douglas called him 8 weeks before he died. Frederick has provided a written statement describing that conversation and its substance. I can provide you the statement, or you can take my characterization of it and let that inform your client conference." Stephen Holt looked at me for a moment with the expression of an attorney who is deciding something. Then he said, "I will take your characterization for now." I said, "Douglas told Frederick that his family was going to make a move after he died. He told him that if anyone contacted him claiming Douglas had changed his estate documents in his final weeks, Frederick should immediately make clear that Douglas had expressed no such intention to him. Frederick followed those instructions. His statement is detailed and specific and will be compelling to a court." The room was quiet again. Conrad turned from the window and looked at me. His voice when he spoke was different from the voice he had used at the beginning of the meeting. The certainty was gone from it. What was left was something more complicated, the voice of a man who is beginning to understand that the person across the table from him is not who he believed her to be and is now trying to revise the map quickly enough to locate himself on it. He said, "You knew. You knew what we were doing before we did it." I said, "I prepared." There is a difference between knowing and preparing, and the difference is the 3 weeks I spent building this before your attorney filed his notice of appearance. He said, "How long have you known what we were going to do?" I said, "Long enough. I watched your family establish the Hartwell Family Trust 2 months after Douglas's first hospitalization. I recognized what that meant. I prepared accordingly." He said, "Douglas never told us what you did. What you actually do." I said, "No." He respected my privacy in that regard. He also knew it was not information his family would use well if they had it. Conrad was quiet for a moment. Then he said something that was not what I expected, which happens rarely enough that I notice it when it does. He said, "He was proud of you. He talked about you in a way that none of us understood. He said you were the best attorney he had ever seen, and he had been saying it since the first year of your marriage." I thought it was something a husband says. I did not understand that he was being literal. I said, "He was usually being literal. That was one of the things I valued about him." Conrad looked at the table. He looked at the documents arranged in front of me. Then he looked at Stephen Holt and said, "Let us go." They stood. Stephen Holt gathered his materials efficiently. He paused at the door and turned back to me and said, with the professional courtesy that I have always found to be one of his genuinely admirable qualities, "I will be in touch within 48 hours, Sylvia." I said, "I know you will, Stephen." They left. Rosalind and I sat at the table for a moment after the door closed. Then she said, very quietly, "Barbara Kern." I said, "What about her?" She said, "You have had that in your pocket for 8 years." I said, "I have had it in the file for 8 years. I retrieved it when it became relevant." She said, "You retrieved it and then you held it until the exact right moment in the presentation." I said, "Sequence matters in these settings. You know that." She said, "I know. I just want to make sure I am learning from what I am watching." I said, "What are you learning?" She said, "That precision is more frightening than volume. That you present the thing that closes the door last, not first. That you let the opponent reach their own conclusion about the impossibility of their position rather than stating the conclusion for them." I said, "Yes. All of those things." She said, "And the 48 hours?" I said, "What about them?" She said, "You gave them exactly enough time to make a rational decision. Not so much time that they can regroup and find another angle. Not so little time that they feel pressured into irrationality." I said, "Stephen Holt is a rational attorney. He will give his clients a rational assessment. 48 hours is enough time for that assessment to land." She picked up her notepad. She said, "Should I start drafting the stipulation language so we are ready when they call?" I said, "You read my mind." We gathered the documents. We replaced them in the folder in the same order I had presented them, not because we needed them in that order anymore but because orderly return is the same discipline as orderly presentation and I do not practice it selectively. Then we walked out of the conference room and down the hallway and into the elevator and out through the building's lobby and into the November air outside. It was cold. The sky was the particular flat gray of late autumn in this city, the kind of sky that has given up on being interesting and is simply being present. I stood on the sidewalk outside the building for a moment and breathed it in and thought about nothing in particular for approximately 15 seconds, which was the longest I had allowed myself to think about nothing in particular since the morning Douglas died. Then I thought about him in the conference room we had been in on the second day of that continuing education seminar, arguing about the burden of proof in a hypothetical case with a woman he had met at breakfast that morning, and I thought about the specific quality of the attention he brought to an argument when he was genuinely engaged with it, the way he would stop and reconsider and say, out loud, That he was wrong about something, which is vanishingly rare in the legal profession and which I had recognized on day 2 as the sign of a person worth knowing. I thought about that for 15 seconds. Then I walked to the car. Rosalind was already on her phone, which I had expected. I started the engine and drove home and made coffee and sat at the kitchen table and began reviewing the draft stipulation language she had texted me before I had finished the first cup. The 48 hours began. I spent them working, which was the only way I knew how to spend time that was technically waiting but that felt, in practice, like a continuation of the building I had been doing since that Tuesday evening in my office 3 weeks before Douglas died. I drafted the full stipulation language and sent it to Rosalind for review. I pulled the case file for the Barbara Kern matter and prepared a clean excerpt in case Stephen Holt asked for it, which I did not think he would, but preparation does not excuse itself because the probability of need is low. I reviewed the asset inventory one more time to confirm I had a complete baseline against which to assess whatever accounting the Hartwells provided of their post-death administrative actions. I also, on the second evening of the 48 hours, sat in the living room of the house on Alderton Lane in the chair that faced the west window, which Douglas had positioned there specifically for the afternoon light, and I let myself simply sit in it for a while. Not reviewing. Not preparing. Not building anything. Just sitting in the chair he had chosen, in the light he had said looked like something worth looking at, and letting the house be the thing it was, which was the house we had built together over 11 years and which was still here, which was still mine, which was still exactly what he had intended it to be. That was not nothing. That was, in fact, the thing I had been protecting all along. Stephen Holt called 39 hours into the 48. He said his clients were prepared to proceed on the framework I had outlined. I said, all of it? Including the individual acknowledgements. He paused for a moment and then said, including the individual acknowledgements. Margaret required some time to come to that decision, but she has come to it. I said, I will send you the draft stipulation for review. I expect we can have a final version ready for execution within the week. He said, I think that is realistic. He said, Sylvia, for what it is worth, and I understand if it is worth nothing to you in this moment, but I want you to know that I did not know the full circumstances of the execution when I filed the notice. I was told it had been executed properly. I reviewed the document and the attestation and they appeared to meet the formal requirements. I was not told about the circumstances in the room. I said, I believe you, Stephen. He said, thank you. I said, I will send the draft by end of day. I ended the call and sat for a moment. Then I called Rosalind and told her the call had come and to finalize the draft stipulation for transmission. She said she had already finalized it. I said I was not surprised. She said she knew. I sent the draft by 4:15 in the afternoon. The stipulation was ready for execution 3 days later. The signing was scheduled for the following Thursday. The signing was scheduled for 10 in the morning on a Thursday, 3 weeks and 2 days after Douglas's burial. Stephen Holt's office, the same building, a different conference room, smaller than the pre-hearing room, which felt appropriate, the way a room contracts when a thing is being concluded rather than contested. I arrived with Rosalind at 9:52. Stephen Holt was already there, the documents arranged in front of him in the order they would be executed, which was the order I had specified in the draft. A mobile notary was seated at the end of the table with her equipment and her log. She was a woman I had not met before, not Barbara Kern, which was an obvious necessity that Stephen Holt had handled without being asked, which told me something about the degree to which he understood what he was managing on behalf of his clients. The Hartwells arrived at 3 minutes past 10. Margaret first, which did not surprise me because Margaret always arrived first when she was arriving somewhere that mattered, because arriving first is a form of control and control was the grammar of Margaret's relationship to every room she entered. She was dressed in a dark coat over dark clothes, which was still appropriate for the mourning period and which also communicated, whether she intended it to or not, the weight of what this mourning was. She looked at me when she came in. She did not look away immediately the way people sometimes do when they are avoiding acknowledging something. She held the look for a moment, not warmly, but steadily, and then she sat down in the chair that Stephen Holt indicated and folded her hands on the table in front of her. Conrad came in behind her and sat without looking at me at all. He had the quality of a man who has made peace with a decision he cannot undo by the method of not looking directly at the evidence of it. I did not find this contemptible. It is a very human method of managing a loss, and what Conrad was managing this morning was a loss, not of money, not of property, but of the narrative he had been living inside, the narrative in which he was the one who handled things and protected the family and managed what needed managing, and in which the woman his brother had married was a manageable element of the situation. That narrative was not operative anymore, and Conrad knew it, and the way he was sitting in that chair was the posture of a man who is getting through a morning that is necessary and unwanted. Patricia came in last. She sat across from Conrad and she looked at me, and the look she gave me was the most complicated thing I had seen in that room so far, which is saying something because the room contained Margaret Hartwell sitting across a table from her son's widow about to sign a document acknowledging that everything she had spent months building had been dismantled. Patricia's look was not guilty and not relieved and not satisfied and not regretful. It was all of those things in some proportion I could not precisely measure, the expression of someone who has done the right thing at real personal cost and is still in the process of understanding what that cost will look like over time. I gave her a small nod. She gave me one back. That was the entirety of what passed between us, which was appropriate. Some moments do not need language, and the introduction of language into them is a diminishment. Stephen Holt opened the proceedings efficiently. He reviewed the terms of the stipulation aloud, not reading the full text but summarizing each substantive provision so that everyone at the table had a clear verbal record of what they were agreeing to. The unconditional withdrawal of the codicil and all associated claims. The confirmation of the validity of Douglas's original estate documents as his genuine and informed expression of his wishes. The full accounting of administrative actions taken regarding estate assets since Douglas's death, which had been provided to me 3 days earlier and which I had reviewed and confirmed was complete. The return of one asset that had been moved in the interim period, a relatively minor matter involving the transfer of a brokerage account sub-account into the Hartwell Family Trust's name, which was being reversed as part of the resolution. He reviewed the individual acknowledgments. He stated clearly that each of the 3 Hartwell family members present was being asked to sign an acknowledgment, held privately by me and not filed with the court, confirming that Douglas's original estate documentation reflected his genuine and informed wishes. He asked if there were any questions before execution. There were none. The notary prepared the documents in the order of execution. Margaret signed first, which was the order I had specified, because I had thought carefully about the sequence and had decided that Margaret's signature needed to come first for the same reason her motivation needed to be understood first, because she was the center of gravity around which everything else in the Hartwell family oriented, and her signature without hesitation or last-minute negotiation was the thing that would determine the texture of the entire proceeding. She signed without hesitation. She signed the way she did everything, with precision and without visible disturbance, her handwriting firm on the page, the pen moving through her name in a single continuous motion. She did not pause before signing. She did not look at the document for a long moment before putting pen to paper. She simply signed, the way a woman who has made a decision signs things once she has made the decision, because Margaret Hartwell was not a person who made decisions and then faltered at the execution of them. Even this decision, the decision to acknowledge in writing that the thing she had spent months building was not going to stand, she made cleanly and executed precisely. I watched her sign her name and I thought about the Christmas dinner in our first year of marriage when she had said through the kitchen pass-through that she did not understand what Douglas saw in a woman who argued for a living. I thought about the particular quality of that statement, the way it framed me as an object of confusion rather than a subject worth understanding, and I thought about the distance between that statement and the document she had just signed. And I thought that the distance between those two things was 11 years and one Tuesday evening in my office after hours and approximately 40 hours of preparation over the 11 days between Douglas's burial and the pre-hearing conference. Conrad signed next. His signature was different from Margaret's, less controlled, the handwriting of a man whose hand is moving before his mind has fully committed to the motion. He put the pen down as soon as he was done and looked at the window, the same gesture he had made in the pre-hearing conference room, which I was beginning to understand was Conrad's particular method of not being where he was when where he was had become untenable. Patricia signed last. She read the document before she signed it, which I appreciated, not because I needed her to read it but because it was the act of a person who takes seriously the things she puts her name to. Her reading of it was not performative. She was actually reading it. When she finished she held the pen for a moment and then she looked up at me and she said, quietly enough that it was between the two of us and not directed at the rest of the room, "I am sorry it took me 6 weeks." I said, "You came." She said, "I should have come sooner." I said, "Patricia, you came. That is what matters." She looked at me for another moment and then she signed her name and set down the pen and sat back in her chair and the room was quiet for a moment in the way rooms are quiet when something that has been building for a long time has just concluded. The notary stamped and logged the documents. Stephen Holt distributed the executed copies according to the agreed allocation. I placed my copies in my folder without reviewing them, because I had reviewed the documents thoroughly before this morning and I did not need to review them again. The meeting concluded. People gathered their things. Conrad left first, which was the reverse of the order they had arrived in. Margaret stood and said something to Stephen Holt in a low voice that I did not try to hear. Patricia stood and picked up her coat and looked at me one more time and then she left. Margaret was the last Hartwell to leave the room. She paused at the door, not in the way people pause when they are going to say something dramatic, but in the way people pause when there is something they have considered saying and have decided to say after all. She turned back to look at me. She said, "He was happy with you." I did not understand it for a long time but I want you to know that I know it was true. Whatever else is true, that is true. I said, "I know." She said, "I hope you know it was not about you." I said, "I know that too." She looked at me for another moment. Then she said, "The house looks like him. The color of the walls. He called me the day he picked it and told me it was the color of light through leaves and I told him that was not a paint color, that was a description of a feeling, and he said that was the point." I said, "That was the point." She nodded once. Then she left. I sat in the conference room after everyone had gone. Rosalind was gathering the last of our materials and I sat and looked at the window and let the morning be what it was for a moment. I was not experiencing triumph. I want to be accurate about that, because I think people expect a moment like this one to feel like triumph and in my experience it does not. What it feels like is the particular stillness that comes after you have been holding something very carefully for a long time and you have finally been able to set it down. The careful holding was over. The structure I had built had held. Everything was where Douglas had intended it to be. What remained now was the understanding of what the silence had cost the people who had attempted what they attempted, and I want to be precise about this because I do not think the costs were simply legal or financial. I think the most significant costs were something else entirely, and I think those costs are worth naming because they are the costs that last. Margaret Hartwell had believed, for 11 years, that she was the primary authority in her son's life and that his relationship with me was a deviation from that authority that would eventually correct itself. The document she had just signed said something different. It said, in language designed to be unambiguous, that Douglas had made his choices clearly and deliberately and that those choices had been valid and genuine and fully informed. It said that the woman he had chosen to build his life with had known what was coming and had prepared for it with the precision of someone who understood exactly what was at stake. And it said that the move Margaret had spent months orchestrating had been anticipated, countered, and resolved before it ever reached a courtroom, by the woman Margaret had spent 11 years deciding was not worth understanding. That was not just a legal defeat. What Margaret Hartwell signed that morning was a document that collapsed the 11-year narrative she had been living inside, the narrative in which Douglas's love for me was something she did not understand and therefore did not have to fully credit, the narrative in which I was an attachment to her son rather than a person he had genuinely chosen. She signed her name to an acknowledgement that her son had chosen me with full knowledge and full intention, and she had to carry that acknowledgement out of the conference room and into the rest of her life. I do not know what she did with it. I do not know what her relationship to that knowledge looks like in the privacy of her own mind. But I know she signed her name to it, and it is real, and it is not going to stop being real because she finds it difficult. The cost to Margaret was the narrative. That is the most significant thing she lost. Conrad Hartwell lost something different. Conrad had built his sense of himself around being the one who handles things, and what he had discovered in the 11 days between the notice of intent to file and the pre-hearing conference was that there was a category of thing he had not known how to handle because he had not known it existed. He had not known what I was. He had not known what I had already built. He had not known that the woman across the table from him in that conference room had spent 3 weeks before his brother's death constructing a legal architecture specifically designed to make everything Conrad was planning irrelevant before Conrad made his first move. The experience of discovering that, in real time, across a conference table, with the documents laid out in front of him in the order I had chosen to present them, was something Conrad was going to have to integrate into his understanding of himself and his capabilities for a long time. He was not a stupid man. Stupid men are, in a way, protected from certain kinds of knowledge because the knowledge cannot find purchase in them. Conrad was intelligent enough to understand exactly what had happened and exactly what it meant, which is that he had walked into a contest he was not equipped for against an opponent he had never adequately assessed, and the assessment failure was not incidental to his defeat, it was the cause of it. He had reduced me to a problem and had therefore stopped gathering information about me, and the information he had stopped gathering was the information that would have told him the contest was lost before it began. That understanding is something he will carry. I do not say that with satisfaction. It is simply the nature of the cost. Patricia's cost was the most complicated of the three and the one I found myself returning to most often in the weeks after the signing. She had done the right thing. There is no ambiguity about that in my mind. She had done the right thing and she had done it at real personal cost, and those two facts coexist without resolving each other into something simpler. What she had lost was the uncomplicated version of her family loyalty, the version that does not require you to examine too carefully what loyalty is being asked to protect. She had been loyal to Douglas, in the end, rather than loyal to the Hartwell family's version of what Douglas would have wanted. And those two loyalties had turned out to be different things, and the discovery of that difference had cost her something in her relationship with Margaret and Conrad that I did not know how to calculate from the outside and did not feel it was my place to calculate. I thought about Patricia often in those weeks. I thought about what it cost to sit in a room and watch someone you love sign something they do not understand and say nothing at the time, and I thought about what it cost to carry that for 6 weeks and then to walk to a door and knock on it and tell the truth. I did not contact her after the signing. I did not think it was my place and I did not think she needed me to. But I thought about her, and I hope, wherever she is in her relationship with what she did and what it cost, that she has arrived at the understanding that telling the truth about something hard is not a betrayal of love. It is, in most cases, the most faithful expression of it. I had 3 conversations I needed to have in the weeks after the stipulation was signed. The first 2 I had anticipated. The third I had not. The first was with Frederick Alden. I called him on the Friday after the signing, which was 10 days after the pre-hearing conference at which I had told Stephen Holt about his statement without showing it to him, which was itself a decision I had made carefully, because showing a piece of evidence at the moment it has maximum impact is different from showing it at the earliest available opportunity. And timing in a legal setting is a form of precision that deserves the same attention as everything else. Frederick picked up on the first ring. I thanked him for what he had provided, for picking up the phone when I called, for being accurate about what Douglas had told him, for understanding that accuracy in that moment was the most useful thing he could offer. Frederick said Douglas had asked him because he trusted him to do the right thing when the time came, and that Douglas had been very clear about what he thought was coming and very calm about it. I said, that sounds like him. Frederick said, it was extremely him. He called me, laid out the situation with complete specificity, told me what he wanted me to do if it happened, and then said, the way you would say something you have finished thinking about and have decided, he said, Sylvia will handle the rest of it. And that was that. He moved on to something else. He asked me how my daughter's residency was going. We talked for 40 minutes about other things. He had said what he needed to say and he had trusted it to land and he was done with it. I said, he was done with it. Frederick said, he was completely done with it. That was what struck me. He was not worried. He was not agitated. He had made a plan and he trusted the person he had made it with and he was done worrying about it. I said, the person he had made it with did not know he had made it. Frederick was quiet for a moment. Then he said, I think he knew you were already making your own plan, Sylvia. I think he knew you well enough to know you did not need to be coordinated with. He was not making the plan for you. He was putting a piece in place that he knew how to put in place, because it was his relationship with me and not yours, and then he trusted you to have done everything else. I sat with that for a moment. Then I said, he was usually right about things like that. Frederick said, he was. He was an extremely accurate assessor of people. It was probably his best professional quality. He could tell you within 20 minutes of meeting someone how they were going to behave in a high-pressure situation, and he was almost never wrong. We talked for a long time after that. Not about the case, not about the Hartwells, but about Douglas. About the cases they had worked together in the early years of the firm, the ones that had been formative, the ones that had been instructive, the ones that had been simply funny in the way that legal situations are sometimes funny when enough time has passed. About the quality of his attention in a meeting, the way he could listen to opposing counsel for 40 minutes and then produce a 3-sentence response that dismantled the entire argument without appearing to be in opposition to it. About the laugh he had when something genuinely surprised him, which was rare, because Douglas was hard to surprise, and therefore when you did surprise him the laugh that came out of it was the real one, the uncalculated one, and it was a very good laugh. I let myself cry a little after that call. The quiet kind, not the kind that comes with sound, the kind that is more like something releasing than something breaking. I had been holding so much for so long and Frederick had just given me 40 minutes of Douglas the way Douglas actually was, not the Douglas of documents and intentions and estate law, but the Douglas who asked about birds and chose paint colors and called his law partner from a hospital bed 8 weeks before he died and laid out a plan and then trusted it and moved on to other things. I had needed that. I had not known how much I had needed it until I had it. The second conversation was with Rosalind. I took her to dinner 2 weeks after the signing, at a restaurant we had been to before for professional milestones, because this was a professional milestone and I wanted to mark it appropriately. I told her that what she had done across those 11 days, the records requests, the coordination, the expert statement facilitation, the draft stipulation, the presence in the conference room, had been exactly the kind of work that is easy to underestimate because it is executed so cleanly that it does not draw attention to itself. I told her that the absence of visible seams in the preparation she provided was itself the evidence of its quality. She said, I learned to work seamlessly by watching someone who works seamlessly. I said, flattery is not a professional quality I prioritize. She said, it is not flattery. It is an accurate assessment. I said, I am increasing your partnership stake. She looked at me across the table. She said, Sylvia. I said, you have earned it. You earned it before this case and this case made it impossible for me to continue delaying the formalization. She said, I want to argue with you about the percentage. I said, you are welcome to try. She said, 40%. I said, 35. She said, 37.5. I said, done. She picked up her glass. She said, to Douglas. I picked up mine. I said, to Douglas. We drank. The third conversation was the one I had not anticipated, and it came 3 weeks after the signing, on a morning when I was in my office reviewing a new client file and my phone rang with a number I did not recognize. I answered it. The caller introduced herself as a woman named Helen Marsh. She said she had been given my name by Patricia Hartwell. I sat with that for a moment. Patricia had given someone my name. In the weeks since the signing I had thought about Patricia often and had not contacted her, but she had, apparently, been thinking about something too. Helen Marsh said she was calling because she was in a situation she did not know how to characterize except to say that her husband had died 6 weeks earlier and his family had begun moving in ways that frightened her, and she did not know whether she was seeing what she thought she was seeing or whether she was simply a grieving woman whose grief was making her suspicious of things that had innocent explanations. I said, "Tell me what you have observed." She told me. She described the sequence of events in the weeks since her husband's death with the particular detail of someone who has been paying close attention, because attention is what you have when the people around you are moving in ways you do not entirely understand. Family members visiting more than they had in years. Conversations that stopped when she entered rooms. A request from her husband's brother to discuss estate matters as a family before involving attorneys. A comment from her mother-in-law that some of her husband's wishes in his final weeks had not been formally documented. I recognized every element of what she was describing. I recognized it the way you recognize something you have lived through yourself, not just professionally observed, but inhabited, which is different. I said, "Helen, I want to ask you some questions about your husband's estate documentation. Not to alarm you, but because the answers will tell me what I need to know to assess what you are dealing with." She said, "All right." I asked her the questions. She answered them. The picture that emerged from her answers was not identical to my situation, but it had the same shape, the same underlying architecture of a family that had decided a widow was a problem to be managed rather than a person to be supported, and was in the early stages of moving to manage her. I said, "I want you to come in this week. Not to commit to anything, just to come in so I can review what you have and give you an honest assessment of where you stand and what your options are." She was quiet for a moment. Then she said, "Patricia said you would say that. She said you would say come in, and she said I should come in." I said, "Patricia was right." She said, "She told me what happened. Not everything, she was careful about what she shared, but enough for me to understand. She said you knew what was coming before it arrived and that you had built something to meet it before anyone made a move. She said I should call you now, before anything formally happens, because now is when it matters." I said, "She is absolutely right about that. Come in on Thursday. Bring everything you have. The estate documents, any communications from the family in the weeks since your husband's death, anything that struck you as unusual or worth noting. Bring it all and we will look at it together." She said, "I will." I said, "Helen, one more thing. Are you all right?" She was quiet for a moment. Then she said, "I do not know yet. I think I will be." I said, "You will be. Call the office to confirm Thursday." I ended the call and set the phone on my desk and sat with the particular feeling that comes when a thread connects itself to another thread in a way you did not plan, but that makes complete sense once it has happened. Patricia had given Helen Marsh my name. Patricia, who had come to my kitchen table 6 weeks after her brother's death and told the truth about what she had witnessed, had taken what she had done and had extended it forward into something new, something that was not an act of repair toward me but an act of care toward a stranger who was standing at the beginning of exactly the situation Patricia now understood from the inside. That was not nothing. That was, in fact, something significant about who Patricia Hartwell was when she was operating from her own judgment rather than from the management of her family's position. It was something I had not known about her in 11 years of family dinners and careful observation, which meant there were things about people that observation does not surface, things that only become visible when the circumstances require them. I thought about that for a moment. Then I opened the new client file and began making notes for Thursday. The estate on Alderton Lane was intact. The house was mine. The investment accounts were mine. The personal property Douglas and I had accumulated over 11 years was distributed exactly as he had designated it, held in trust according to the structure I had built in the first year of our marriage and never had reason to alter. Everything was where he had intended it to be. And now there was a woman named Helen Marsh coming in on Thursday who needed the same thing I had needed, which was not a miracle and not a rescue but a structure, something solid enough to hold what mattered when other people were reaching for it. That is what I do. That is what I have always done. Douglas used to say, I learned this from Frederick on the phone call I will carry with me for the rest of my life. Douglas used to say to Frederick that the people who came to me came when everything was going wrong and that I knew how to hold the line for them. He said it like he was proud. Frederick said he said it like he was describing something he found genuinely moving, not just professionally admirable but actually moving, the way certain things are moving when you have watched them close enough and long enough to understand what they cost. I built the line for myself when it mattered. I held it. Now I was going to build it for Helen Marsh. Thursday was 3 days away. There was work to do before then and I began it, the way I begin everything, with a clean page and a specific question about what I needed to know and what I needed to build and in what order. The grief was still there. It had not gone anywhere and I had stopped expecting it to. It had changed shape in the weeks since the signing, had become something I carried rather than something that moved through me unpredictably, and the carrying was its own form of faithfulness, the dailiness of it, the way it sat alongside the work rather than stopping it. I had decided somewhere in the evenings in the Westlight living room that this was what I had to offer the grief, not its resolution, not its transcendence, but my continued presence inside the life it lived alongside. I was going to keep doing the work. I was going to keep building the structures that held what mattered. I was going to keep being the person Douglas had known I was, the person he had been proud of in a way he described to Frederick with the specificity of someone describing something he found genuinely beautiful. Holding the line. That was the description he had found for it. I was still holding it. I turned back to the file on my desk and kept working. I want to tell you about a Tuesday afternoon in February, 3 months after Douglas died, 3 months after the birds came through the open window and the house on Alderton Lane went quiet in the particular way that houses go quiet when the person who made them feel inhabited is no longer in them. It was the kind of February afternoon that does not commit to anything. Not cold enough to feel dramatic, not warm enough to suggest anything was changing. The sky was the flat white of a season that has decided to simply persist rather than perform, and the bare tree in the parking lot outside my office window had been standing in that same posture of suspended decision since December, neither dead nor budding, simply present in the way that living things are present when they are waiting for the right conditions to become what they intend to become. I had been watching that tree for 3 months. It had not done anything interesting yet. I found this oddly companionable. I was in my office at 2:15 in the afternoon reviewing documents for Helen Marsh. Helen had come in on the Thursday I had scheduled, 3 days after her call, with 2 folders and a small leather notebook in which she had recorded, in precise and careful handwriting, every communication she had received from her husband's family in the 6 weeks since his death, annotated with dates and times and the names of who had said what and in what context. I had looked at that notebook for approximately 90 seconds before I understood something important about Helen Marsh, which is that she was someone who paid attention with the same quality of attention that Douglas had paid to things, the kind that accumulates quietly over time and becomes, when you need it, exactly the right information in exactly the right form. I had told her that the notebook was going to matter. She had said she had not known whether it was worth keeping. She had started it because she had the feeling, in the weeks after her husband's death, that she was watching something happen that she needed a record of, and she had not been certain the feeling was reliable or whether she was simply a grieving woman whose grief was interpreting ordinary family behavior as something more threatening than it was. I had told her that the feeling was reliable. I had told her that the notebook was evidence. She had looked at me with the expression of someone who has been validating their own perception against a resistance of uncertainty for long enough that external confirmation of it produces something closer to relief than satisfaction. Her situation had the same underlying architecture as mine, the same family moving in the same direction with the same confidence that a widow who had recently lost her husband was a manageable element of the estate rather than a person with agency and preparation. The specific details were different. Her husband's name was Thomas. His family was smaller than the Hartwells, a mother and 1 brother, but what they lacked in numbers they compensated for in coordination, the mother and brother operating as a unit with a shared attorney and a shared account of Thomas's final wishes that bore, in Helen's assessment and in my assessment after reviewing her documentation, a suspicious relationship to what Thomas had actually expressed to her in the months before his death. There was no codicil in Helen's situation, not yet, but there was a verbal claim, made by the brother to Helen in the week after Thomas's funeral, that Thomas had expressed a desire in his final weeks to ensure that certain assets, specifically a commercial property that Thomas had inherited from his own father and that represented the largest single asset in the estate, were preserved within his family of origin rather than passing through the estate in the manner his documents specified. The brother had said this in the careful language of someone who has been advised on how to frame a claim like this one, not as a legal assertion but as an expression of family sentiment, the kind of framing that is designed to make a widow feel that contesting it would be an act of disrespect rather than an act of self-protection. I recognized the framing. I had heard variations of it across 17 years of practice. I had heard it in its most sophisticated forms and its clumsiest forms and in every form in between, and what they all had in common was the premise that the widow's grief made her a less reliable assessor of her own interests and therefore more receptive to a redefinition of those interests by the people around her. It was a premise that I had spent 17 years contesting professionally and had spent the 11 days after Douglas's death contesting personally, and I was not going to sit across from Helen Marsh and watch it operate without naming it. I had named it. I had told Helen exactly what the framing was designed to do, and I had told her that the correct response to it was not confrontation and not capitulation but documentation and preparation, the same things I had done, the same things I was now building for her. I had told her to keep the notebook and to add to it every day and to note every communication from the family, no matter how innocuous it appeared, because in a proceeding like the one that might be coming, the pattern of communication is often more revealing than any individual communication, and the pattern requires a record to be visible. She had kept the notebook. She had added to it every day. The 2 folders she had brought to our first meeting had become 4 folders by the second meeting and 6 by the third, not because the family was accelerating their activity but because Helen was becoming more precise in her documentation, more confident in her assessment of what was worth noting, more certain that the feeling she had had in the first week after Thomas's death was not grief distorting her perception but perception accurately registering what grief was happening alongside. She was, I had come to understand over the course of our meetings, a very specific kind of person. She was the kind of person who does not make claims she cannot support and does not support claims she has not examined, which is an uncommon quality in my experience. The kind of epistemic discipline that most people believe they have and that very few people actually practice with consistency. She reminded me, in this quality, of Douglas. Not in other ways, she was warmer than Douglas and less interested in argument for its own sake and more inclined toward the emotional texture of situations where Douglas had been inclined toward the structural texture. But in that particular quality of not asserting more than she could demonstrate, she reminded me of him. I had noticed this and had not said it to her because it was not the kind of observation that belongs in a professional relationship and also because it was mine. It was something I was keeping for myself in the quiet accumulation of things you keep for yourself when you are grieving someone and the world keeps producing people and moments that remind you of what you have lost. I kept a small internal inventory of those moments. The bird Frederick had identified as a junco. The February light through the west window that was the color Douglas had said was like light through leaves. Helen Marsh's epistemic discipline in a small leather notebook. These were the kinds of things that grief collects when it is behaving well, which is to say when it is not stopping you from working but is instead moving alongside the work, accumulating its own record of what was worth keeping. I was reviewing Helen's documentation at 2:15 on that Tuesday afternoon when my phone rang. The number on the screen was not in my contacts. I almost let it go to voicemail, mid-afternoon with a client file open in front of me, but the nature of my work means that critical calls sometimes arrive from numbers I do not recognize, and the habit of answering unknown numbers is one I have maintained for 17 years. I answered. The caller was a woman named Catherine Park. She identified herself as the administrator of a medium-sized estate in a county 2 hours north of mine, and she said she had been given my name by Dr. Andrea Solis, who had been contacted by Catherine's office in the course of research Catherine was conducting on a probate matter with certain characteristics that Dr. Solis had mentioned sounded familiar. I said, "What kind of characteristics?" Catherine said, "A codicil alleged to have been executed during a period of palliative care." A notary with a complicated professional history in the jurisdiction. A family trust established in close proximity to the primary estate holder's diagnosis. I was quiet for a moment. Not because I was surprised, exactly, but because I was registering something, the particular registration of a pattern that you have seen once in your own life and are now seeing again in another person's life, and the recognition carries with it the specific weight of knowing what the person at the center of that pattern is currently experiencing. I said, "How many people are involved on the family side?" She told me. The number was larger than the Hartwell situation, 4 siblings rather than 2, and the assets were larger, and the family structure was more complex in the ways that larger families are always more complex, more moving parts, more people whose individual interests do not perfectly align but who are coordinating around a shared objective. The time pressure was significant because a preliminary probate hearing had been scheduled for 6 weeks out. I said, "And the widow? Tell me about her." Catherine was quiet for a moment, as though the question had surprised her slightly, which it might have, because most of the inquiries she would have made in the course of estate administration would have been about assets and instruments and procedural timelines rather than about the person at the center of the situation. Then she said, "Her name is Margaret. She is 63. She was married to her husband for 31 years. She is not an attorney and she does not have a professional background in estate law. She has been trying to manage this on her own for the first 2 months and she is, in Catherine's assessment, someone who is very good at managing things and is currently being managed herself by people who are better resourced and more legally sophisticated than she is." I said, "Send me everything you have. Documentation of the codicil claim, the family trust registration, the estate documents, the medical records if they are available, Catherine's own notes on the communications between the family and the widow since the husband's death. Everything. Send it by end of day." Catherine said, "Dr. Solis said you would want everything." I said, "Dr. Solis is accurate about most things." Catherine said, "She also said, and I hope you will take this in the spirit in which it is intended, she said you would want everything because you know what it is to be where Margaret is right now, and that knowing it from the inside is what makes you different from the other estate litigators she could have recommended." I sat with that for a moment. Then I said, "Dr. Solis is perceptive as well as accurate." Catherine said she would send everything by 5 o'clock. I thanked her. I ended the call. I set the phone on my desk and looked at the window and the flat white February sky and the bare tree that had not yet decided to do anything about spring. I thought about Margaret, 63 years old, 31 years of marriage, managing something on her own that she was not equipped to manage on her own because she did not know what I know, which is not a failing of hers but simply the consequence of never having needed to know it before. I thought about the moment 2 months ago when she had tried to manage it on her own and had not known what to call what she was seeing, whether it was a real threat or grief distorting a normal situation into something more frightening than it was. I thought about the notebook Helen Marsh had brought to our first meeting. The careful handwriting, the dates and times, the annotated record of what had been said and by whom, the evidence of someone paying attention in the way that Douglas paid attention, which is to say with the specific intention of not losing track of what was true. I thought about Patricia Hartwell, who had given Helen Marsh my name, and about Dr. Andrea Solis, who had given Catherine Park my name, and about the way a thing you do when it is necessary can extend itself forward in time into situations you were not present for and did not plan for, the way the preparation I had made 3 weeks before Douglas died had become, through its consequences and its visibility to the people who had witnessed them, a form of guidance for people I had never met. I did not experience this as legacy. That is too large a word for what I was sitting with on a Tuesday afternoon in February in my office with a client file open on my desk. What I experienced it as was continuity, the specific continuity of a thing that is worth doing continuing to be worth doing, the structure that holds what matters being built again for someone else in a different situation with the same underlying shape. That is what I do. I have been doing it for 17 years. I will continue doing it for whatever years remain in my practice. The cases change. The assets change. The families change in their specific configurations of loyalty and self-interest and the particular damage that love does when it calcifies around the wrong premise. But the underlying thing I am doing does not change. I am holding the line. I am building structures strong enough to protect what matters when other people are reaching for it. I am sitting across tables from people who have decided that a widow or a daughter or a sister is a manageable problem, and I am showing them, with documents in a specific order, that they have miscalculated. I had done this for 17 years as a professional practice. I had done it once as the person inside the situation, and the doing of it from the inside had not changed the nature of the work, but it had changed my understanding of what the work is for, which is something different from understanding the mechanics of it. I had understood the mechanics for 17 years. What the 11 days after Douglas's death had given me was the understanding that the work is not fundamentally about documents or instruments or legal proceedings. It is about people who have built something real and true and are in danger of losing it to people who have decided they have the right to take it. The documents are the tool. The thing the documents protect is the life. Douglas had built a life with me. 11 years of it, in a house with walls the color of light through leaves, with furniture chosen for the quality of afternoon light, with arguments about the names of birds and the burden of proof in hypothetical cases and whether you appreciate things more when you know what they are called. He had built that life with full intention and full knowledge, and he had trusted me to protect what we had built, and I had protected it, and it was still here, and the grief of his absence from it was real and present and not going to become smaller for a very long time, but the life itself was intact, and that was what he had needed it to be. Catherine Park's documentation arrived at 4:43 in the afternoon. 17 minutes earlier than she had said it would, which told me something about her, which is that when she commits to a time she commits to it with room to spare, which is the professional habit of someone who has learned that the margin between the time you say something will happen and the time it actually happens is where your reliability lies. I opened the files. There were 11 documents in the folder she had sent, organized with a clean index at the front that listed each document, its date, its source, and a one-line description of its relevance to the situation. I read the index first, because reading an index is how you understand the structure of what you are about to encounter before you encounter it, and understanding the structure before you encounter the content is a form of preparation that saves time and prevents the kind of reactive reading that leads to missing things. The index told me the shape of what was in the folder. The codicil, dated 8 weeks before the husband's death, executed by a notary whose name I did not recognize but whose commission number I could pull from the county records. The family trust, established 11 months before the husband's death, which was closer to the diagnosis window than I had seen before, which suggested either more planning or more panic, and I would need to review the trust documents to understand which. The husband's original estate documents, which Catherine had obtained from the attorney who had drafted them, and which appeared on the index as having been executed 14 years into the marriage, which meant they were not early documents, they were documents made by people who had been together long enough to know what they were doing. The medical records, which Catherine had flagged as partial, not the full hospice chart, but the records available through the hospital system from the final 3 months of the husband's treatment. Margaret's communications log, which Catherine had compiled from records Margaret had provided, and which ran to 47 pages, which told me that Margaret had been documenting things with the same instinct Helen Marsh had demonstrated, the instinct of someone who knows they are watching something happen and needs to be able to prove it later. 47 pages. 2 months of documentation. She had not known whether it was necessary. She had done it anyway. I thought about that for a moment, the 47 pages, the specificity of that number, the image of a 63-year-old woman sitting at a table or a desk in the weeks after her husband of 31 years had died, writing down what people said to her and when they said it and how they said it, not knowing whether anyone would ever need to read it, not knowing whether the feeling that was prompting her to write it was reliable, but writing it anyway because the alternative was to not have it, and she understood, at some level that had not yet formed into conscious knowledge, that not having it would cost her. She had not known what I know. But she had done, instinctively, the thing that someone who knows what I know would have told her to do, and she had done it for 2 months, which was long enough to have a record. That record was going to matter. I read through the index one more time and then I opened the first document, the codicil, and I began reading it with the specific attention I bring to a document that I am assessing for the first time, which is the attention of someone who is simultaneously reading what the document says and reading the decisions that were made in its construction, because the decisions made in the construction of a document tell you as much as the content does, sometimes more. The codicil was long. Longer than it needed to be, which is itself information, because documents that are longer than they need to be are usually longer because the person who drafted them was trying to establish legitimacy through volume, the way a person who is uncertain of their position sometimes talks too much to fill the uncertainty with sound. A confident document does not need to perform its confidence. It is simply precise. This document was not simply precise. It was elaborately precise, which is a different thing. I made notes in the margin of my legal pad as I read. I noted the date of execution against the medical record dates Catherine had provided. I noted the specific assets named in the codicil and cross-referenced them against the assets named in the original estate documents. I noted the language used to describe the husband's wishes, not the legal language but the narrative language, the sentences that claimed to represent what he had expressed, because narrative language in a legal document is where the fabrication shows. It is where the person writing the document has to produce an account of another person's interiority, and accounts of interiority are the place where documents diverge most visibly from reality when the account is invented rather than observed. I made notes for 40 minutes. At the end of 40 minutes I had 2 pages of notes and a preliminary assessment that the codicil had 4 specific vulnerabilities, 2 structural, 1 procedural, 1 evidential, and that the evidential vulnerability was the one I was going to build the case around because it was the one that was going to be most visible and most decisive to a court. I set down my pen. I looked at the February window. The tree in the parking lot had not moved. The sky was beginning to shift toward the particular gray-blue of late afternoon, the hour when the light stops being general and becomes directional, coming from a specific angle and hitting specific surfaces. The way it hit the west wall of my office in the late afternoon in a way that reminded me, every day at this hour, of the west window in the living room of the house on Alderton Lane. I thought about Douglas. I thought about him the way I think about him now, which is differently from how I thought about him in the first weeks after his death, when the thinking was still raw enough that it arrived without warning and with the full weight of the absence behind it. I think about him now with something more like the quality of returning to a specific place that you know well and that holds a specific quality of light or sound or feeling that you carry with you between visits. I return to him when something prompts it, when the afternoon light is right or when someone demonstrates a quality of attention that reminds me of his, and the returning is not painless but it is not only pain, it is also the thing that love becomes when it does not have anywhere new to go and so it goes deeper into what it already has. I thought about the phone call he had made to Frederick 8 weeks before he died. The specificity of it, the calm of it, the trust of it, the way he had laid out what he expected to happen and what he needed Frederick to do if it happened and then had moved on to asking about Frederick's daughter's residency, because he had said what he needed to say and he trusted it to land and he was done worrying about it. That quality of completion, of being able to say a thing and trust it and move forward, was one of the things I had loved most about him and one of the things I had tried to learn from him and one of the things I was still learning. I had not been done worrying about it. Not then, not now, not entirely. But I had been building, and the building was a kind of not worrying, a practical faith that what you make with sufficient care and sufficient knowledge will hold when it needs to hold. The structure had held. For me, it had held. Now I was going to build it for Margaret, 63 years old, 31 years of marriage, 47 pages of careful notes about what people had said to her and when, sitting somewhere 2 hours north of me in a house that was suddenly too quiet in the particular way that houses go quiet when the person who made them feel inhabited is no longer in them. She did not know what was coming. She knew something was coming. Her notes told me that. Her 47 pages of careful attention to the pattern of what was being built around her told me she had been seeing the shape of it even without the professional knowledge to name all its pieces. But she did not know what I knew about what was coming, and what I knew about what was coming was the thing that was going to make the difference. 6 weeks until the preliminary probate hearing. That was enough time. Barely, but enough, if we moved immediately and if the documentation supported what the index suggested it would support and if Dr. Solis was willing to review the medical records and provide the same kind of expert framing she had provided in my own case. I reached for my phone. I called Dr. Solis's office and left a message asking her to call me when she had a few minutes, that I had a new matter I wanted to discuss with her and that the medical record question was similar in structure to the one she had worked with me on previously. I called Rosalind and told her about the call from Catherine Park and asked her to begin pulling the County Notary Commission records for the notary named in the codicil's attestation. She said she was on it. I said I would send her the full file tonight so she could review it before our morning meeting. She said she would be ready. I ended the calls and sat for a moment in the office with the late afternoon light doing what it did and the bare tree standing in its patient posture outside the window and the Helen Marsh file open on one side of my desk and the Catherine Park documents on the other side and the legal pad in the middle with 2 pages of notes about 4 vulnerabilities in a codicil executed by a family that had decided a widow's grief made her a manageable problem. She was not a manageable problem. She was a person who had paid careful attention for 2 months and had produced 47 pages of record and had accepted an introduction from an estate administrator she had never met to an attorney 2 hours away because someone she had also never met had pointed her in this direction through a chain of referrals that ran from Dr. Solis to Catherine Park to my office on a Tuesday afternoon in February. I was going to build something for her. I was going to build it in 6 weeks from a standing start with the documents Catherine had sent and the notes Helen Marsh had given me the idea of making and the expert framing Dr. Solis was going to provide and the 17 years of practice that told me exactly what the 4 vulnerabilities in that codicil meant and exactly how to present them in an order that would make the structure of what the family had attempted visible to a probate court in language the court could act on. That was what I do. That was what I was going to keep doing for as many years as my practice continued and my mind stayed sharp and people kept sitting across from me with their folders and their notebooks and their careful handwriting and their grief and their instinctive, preverbal understanding that something was happening around them that they needed to be able to prove. I was going to hold the line for Margaret the way I had held it for myself. Not because I knew her, not because I had any particular connection to her situation beyond the professional, but because holding the line is the work. And the work is what remains when everything else has been accounted for, when the grief has found its shape and the documents have been filed and the house on Alderton Lane is quiet in the evenings and the west window shows the light that Douglas said was worth looking at. The work remains. The work is what you do with the life that remains after the loss, not in spite of the grief but alongside it, the grief and the work moving together the way 2 things move together when they have learned to share the same space without requiring each other to be smaller. I turned off the desk lamp. I gathered the Catherine Park documents into a folder and labeled it with her name and the date and placed it in the stack with Helen Marsh's file and 2 other active matters that were waiting for attention in the morning. I put on my coat. I picked up my bag. I turned off the office light and walked down the hallway and out of the building into the February air, which had gotten colder in the hours since the afternoon had shifted toward evening. Cold enough now to be honest about what the season was rather than what it was failing to be. I stood on the sidewalk outside the building for a moment and breathed it in. Then I walked to the car. I drove home to the house on Alderton Lane. I made dinner in the kitchen with the walls the color of light through leaves and I ate it at the table where I had sat with a glass of water on the evening Conrad called me at 8:17 and told me the Hartwells had always taken care of their own. I washed the dishes. I went into the living room and sat in the chair by the west window for a while, the chair Douglas had positioned for the afternoon light, and I sat in it in the evening light instead, which was different from the afternoon light but was still the light of the same room and the same house and the same life. I thought about Douglas. I thought about Margaret, 63, 31 years. I thought about Helen Marsh's notebook. I thought about Patricia Hartwell walking to my front door on the 7th day and standing on the porch with the particular expression of someone who has made a decision they could not unmake and had decided to make it anyway. I thought about Frederick on the phone, talking about Douglas's laugh in a conference room when something genuinely surprised him. I thought about dark-eyed juncos, which migrate through in November, which you hear before you see them, which Douglas knew by sound in the last morning of his life because he had spent decades paying attention to the world in the way that accumulates into quiet knowledge. I had kept what we built. It was here around me in the specific choices of a specific man who had paid attention to everything that mattered and had trusted me to do the same. I had done the same. I was still doing it. There is one more thing I want to say before I go, and I want to say it directly to you, because you have sat with this story for the length of time it takes to tell it, and I think you deserve a direct address. If you have ever been in a room where the people who were supposed to grieve alongside you were instead calculating, if you have ever held the hand of someone you loved and known, with the particular knowledge that comes from paying attention, that the people outside the door were already planning what to do with what that person was about to leave behind, then you know what it means to stand in the gap between what love is supposed to do and what it sometimes does instead. You know what it costs to be precise about that, to refuse to pretend the gap is not there, to hold the line not dramatically but persistently, the way you hold anything that matters, with your hands and your attention and everything you know and have learned and have built over the years of being exactly who you are. That is what I did. It is what I am still doing. If this story reached something true in you, I want to know. Leave a comment and tell me what it reached. Tell me if you have been in a room like this one. Tell me what you held and how you held it. Tell me what you built when you needed something to hold what mattered. Share this with someone who needs to hear it, someone who is standing in that gap right now and does not yet know that it is possible to build something strong enough to close it. Subscribe so that when the next story comes you are there to hear it. There are more stories to tell. There are always more stories. And I will keep telling them for as long as there are people who need to hear that the line can be held. That is the work. That is all of it. I am still here. I am still holding.